Getting divorced. So we're going to talk about whether you can do your own divorce. Yes, you can, and I'm here to tell you how to do it. My name's Stuart Day, and I'm from Fennelly Legal, and we do a lot of family law applications and divorce applications for many clients. So can you get divorced on your own? You can. You don't actually need a lawyer to get your divorce done. Now, many people use a lawyer, and we're always happy to help people that are confident doing it themselves. However, getting divorced is, in relative terms, a reasonably simple process. Provided you reach the criteria for getting divorced, which is A, you are married, and B, you have been separated for more than 12 months, either both of you or one of you can make an application to the Federal and Family Circuit Court of Australia. You'll find their website online, and you can download all the forms yourself there, and they have a terrific section online helping you go through the process. The process is, as I said, reasonably simple in practice. What you need to do is, one, complete the application. Now, there's two ways to complete the application. One is one party does it, and that's fine. The other way is you can actually make a joint application if both of you are willing to get divorced and are happy to sign and complete all the paperwork together. Doing a joint application is the simplest way. It avoids a number of steps in the process and says to the court that you're both happy to get the divorce done. If, however, your ex won't sign a joint application, that's okay as well. There are just a couple of extra steps in the process. So firstly, you need to, once again, go to the website, download the forms and complete them. You'll need a number of documents with that, including a copy of your marriage certificate. And once you have completed the form, you will then upload the documents with that signed application and pay the filing fee. Now, the filing fee will vary depending on whether you have a healthcare or concession card or whether you're a full fee payer. The filing fee can be expensive. It's around over $1,000 at this stage, and that fee goes up annually, so you would need to check what the fee is at the time. Once you have completed your application, you've signed it, you've filed it through the court system and paid the fee, the next step in the process is serving that application for divorce on your spouse. Now, there are requirements around service, and we always recommend the best way to serve your ex is through a process server. A process server is a professional person that serves legal documents on another party. You can do it yourself. You can have a friend or family member do it. However, we don't recommend that. And the reason for that is the court has very specific rules around making sure the making sure the documents were served correctly on your spouse. After the documents have been served, it is also a legal requirement that whoever served the documents prepares, signs and swears an affidavit, which is then required to be uploaded to the court. As you can see, this is an extra step in the process, and if you use a professional process server, they know exactly what they are doing and they will ensure there are no problems with it. If the service on your spouse hasn't been done correctly, this can delay you getting divorced. Once you've served your ex, or your current spouse, soon to be officially your ex-husband or wife, once you have served them and filed the affidavit of service with the court will then determine whether you need to appear in court or not for the divorce to be ratified. Generally speaking, if there are children under the age of 18 of the marriage, an appearance will need to be made at court. This might sound scary, but it really shouldn't be. The court needs to know that the children are healthy, what their health is, whether they're healthy or not, whether they attend school, how they're going in school. Really what the court wants to know is that the children are okay. You can make an application to the court if you do have children under the age of 18 that no court appearance is required. However, that will be at the discretion of the court whether you need to appear or not. In the circumstance where there are no children, or if you do have children, they're over the age of 18, generally no court appearance is required. Provided all your documentation is correct, the court will generally assess your application and then grant the divorce. The divorce won't become legally effective for 1 month from the date the court grants it. It's a bit of a funny system. We're not sure why that is, but it's been the way forever and a day. So you're in 1 month of limbo before you officially get divorced. Clients regularly ask if we can help them with a divorce, and yes, we can. However, we do often say to clients, if you are comfortable with using the internet and downloading forms and filling in forms and using a process server to serve your ex, or even asking your ex if you can make a joint application, you can generally save yourselves legal fees by doing the application yourself. You can always come back to us for help if you've hit a roadblock, because we're always here to help you. So feel free to give us a call or check out our website, but we're always happy to help, even if we don't actually make any money by doing the divorce for you.